like, comment, share, subscribe. Thanks for watching.
Some viewers may find the following video disturbing. Viewer discretion is advised.
In the quiet town of Moscow, Idaho, nestled in the rolling hills of the Palouse, an unimaginable act of violence shattered a close-knit college community. 4 University of Idaho students, bright, ambitious, full of promise, were found brutally murdered in their off-campus home. The crime sent shockwaves through the nation. But the biggest shock came when police announced a suspect, a 28-year-old criminology PhD student studying just across the border. This is the story of Brian Christopher Kohberger and the long, winding path from horrifying crime to a surprise guilty plea. Who was Brian Kohberger? Brian Christopher Kohberger was no ordinary suspect. He was a doctoral student in criminology at Washington State University, just 10 miles from the University of Idaho. With degrees in psychology and criminal justice, he'd studied under leading forensic psychologists and even posted online surveys asking criminals to describe their emotions before, during, and after committing a crime. His online posts hinted at struggles with addiction, isolation, and detachment from reality. Here are a few of his online posts. On May 12, 2011, he posted a forum post titled, "Am I the Only One? I always feel as if I'm not there," completely depersonalized. Depression, no interest in activity, constant thoughts of suicide, crazy thoughts, delusions of grandeur, poor self-image, poor social skills, no emotion. When I get home, I am mean to my family. This started when VS Visual Snow did. I felt no emotion, and along with the depersonalization, I can say and do whatever I want with little remorse. Then on July 4, 2011, forum post titled, "Can you relate? I feel like an organic sack of meat with no self-worth. As I hug my family, I look into their faces, I see nothing. It is like I am looking at a video game, but less." These posts were made when he was around 16 years old and active on a visual snow support forum between 2009 and 2012. They are consistently cited across multiple media investigations as having originated from the account attributed to Brian Kohberger. Back in 2018, Kohberger reportedly told his friend Jack Bayless, "I only used when I was in a deep suicidal state. No one could have imagined that the man fascinated by killers might become one himself." The night of the murders, in the early hours of November 13, 2022, inside a 3-story rental home at 1122 King Road, 4 students were stabbed to death while they slept. 21-year-olds Kaylee Goncalves and Madison Mogan were lifelong best friends. 20-year-old Zana Kernodle and her boyfriend Ethan Chapin were spending the night together. A surviving roommate later told police she saw a masked man dressed in black walking silently through the house with bushy eyebrows. He left no fingerprints, no obvious motive, no forced entry. But he made one mistake. He left behind a knife sheath with DNA on the button snap. The investigation began, and it was extensive and exhausting. For weeks, police remained tight-lipped. Rumors swirled. The community grew restless. Then, surveillance footage revealed a white Hyundai Elantra circling the neighborhood around the time of the murders. The DNA from the knife sheath was uploaded to public genealogy databases. It led to distant relatives. That, in turn, led to one name: Brian Kohberger. Investigators tracked him as he drove cross-country back to Pennsylvania with his father. They retrieved trash from his family's home and confirmed a match. On December 30, 2022, Kohberger was arrested in the Pocono Mountains. He never resisted, never spoke. But the evidence police believed was damning. Kohberger was extradited to Idaho and charged with 4 counts of first-degree murder and 1 count of burglary. Prosecutors announced they would seek the death penalty. The defense pushed back, challenging the DNA process, questioning the cell tower data, and even hinting at an alibi. A sweeping gag order silenced attorneys, police, and the families. The trial date was pushed back again and again. As pretrial motions dragged on, the families of the victims waited and waited. Then, out of nowhere, a plea deal. On June 30, 2025, prosecutors informed victims' families that Kohberger would accept a deal to avoid the death penalty. He would plead guilty to all charges in exchange for 4 consecutive life sentences without the possibility of parole. For many families, this announcement came as a shock. They had not been consulted. Some were outraged. Still, on July 2nd, Koberger stood before a judge and admitted without emotion that he was responsible for all 4 murders.
Under the fair use doctrine of the U.S. copyright statute, it is permissible to use limited portions of a work, including quotes, for purposes such as commentary, criticism, news reporting, and scholarly reports. There are no legal rules permitting the use of a specific number of words, a certain number of musical notes, or percentage of a work. Be sure to like, comment, and subscribe.
Move to the business of today. I understand the state and the defense have reached a plea agreement in this case. For the record, I have a written plea agreement which indicates, in sum, the defendant will plead guilty to all 5 counts in the indictment: burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing, to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35. This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count, so theoretically the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement, will speak for itself and be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well. All right. Ms. Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counteroffers and answered his questions about those?
Yes.
Do you consent to the entry of the plea today?
I do.
All right, Mr. Koberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right, thank you. And now, while you're standing, actually, why don't you take the oath from the clerk?
Do you solemnly swear or affirm that the testimony you shall give in the matter not given before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, and Mr. Koberg, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated, all right? Before I start asking you questions today, have you consumed substantive questions? Let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include on count 1, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime to be enforced in the form of a civil judgment to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with that I understand you're going to plead guilty today to?
Yes.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone, other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Kohlberg, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case should you not plead guilty. Did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
You have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you to understand what the state would have had to have proven at trial had you, as to the crimes that you're pleading guilty to, had you, if you didn't plead guilty. Let me find the document. Hang on a second here. All right. So as to count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count two, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogen, a human being, by stabbing Madison Mogen, from which she died. As to count three, the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Gonzalez, a human being, by stabbing her, from which she died. As to count four, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count five, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
I want to also make, for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogen, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice of forethought?
Yes.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Gonzalez, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice of forethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice of forethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice of forethought?
Yes.
At his sentencing on July 23, 2025, the families faced him directly. They spoke of stolen futures, of empty beds, of unbearable pain. Kohberger did not speak. No apology, no explanation, no motive.
Under the fair use doctrine of the U.S. copyright statute, it is permissible to use limited portions of a work, including quotes, for purposes such as commentary, criticism, news reporting, and scholarly reports. There are no legal rules permitting the use of a specific number of words, a certain number of musical notes, or percentage of a work. Be sure to like, comment, and subscribe.
So now, it is time for the judicial system to impose final judgment and close the door on this chapter of these tragedies. As the court is aware, by the agreement of the parties, it is the state's prayer. Perhaps have the Elmo police turned on. Thank you. That on count one, the felony burglary, that the court sentenced the defendant to the maximum period of 10 years fixed in the custody of the Idaho Department of Correction. Then on count two, that the court sentenced the defendant to fixed life for the murder of Maddie Mogan. On count three, that the court sentenced the defendant to fixed life for the murder of Kaylee Gonzalez. On count four, that the court sentenced the defendant to fixed life for the murder of Xana Kernodle. On count five, that the court sentenced the defendant to fixed life for the murder of Ethan Chapin. And the state further prays that these sentences be ordered to run consecutively, back to back, not at the same time, to recognize and respect the unique individuality of each of these beautiful young people whose lives were taken brutally and for no reason. And hopefully now, as we have heard earlier this morning, it is time to afford the families and the friends and the community and the state of Idaho and the nation and the world to move forward. We can't undo, and we can never undo, the horror of what occurred on the early morning hours of November 13th, 2022 at 1122 King Street in Moscow, Idaho. For a long time, the presiding district judge in Latah County was John Stegner, who eventually became a member and a justice of the Idaho Supreme Court. And Justice Stegner often observed that even God cannot change the past. But everyone in this room has the ability to take themselves forward. And we want the judicial system to afford them the opportunity today to do that. From today forward, our memories should be focused on these innocent victims whose lives were taken, on their families, on their friends, on the community. The court has heard discussion, talk today, reminiscences today about a special family that our victims shared, not just their natural, legal, and biological families, not just their university family within their sororities, for example. But this family. This is the picture taken on November 12th, 2022, of the special family of 1122 King Road. And you can see all 6 of these dynamic, vibrant, loving, special, innocent faces taken together just across the street from their residence, and barely 12 hours before 4 of them would be brutally murdered in their sleep. They've been described consistently as being bright, caring, vivacious, with futures we can only imagine now. But they were, and they remain, a special family that I think we should all recognize and appreciate. So it's time to move forward. There have been a number of statements directed specifically at the defendant today. I have one last thought. After Your Honor imposes judgment and sentences the defendant to spend the rest of his life in prison, in other words, sentence the defendant to die in prison, he's going to stand up in the belly chains and leg irons that he's wearing today, and he's going to be escorted into the custody of the Idaho Department of Correction. And the door will close behind him forever. That is the closure that we seek, that all of these people, these loving friends and family deserve, so that we can move forward. Thank you, Your Honor.
Thank you. All right, does the defense have evidence to present today?
No evidence.
All right. Does defense wish to make argument today?
Runner, we do not wish to make arguments. Mr. Koberger, along with his legal team, is prepared for the court to enter judgment.
All right, Mr. Koberger, you have an opportunity to make a statement if you wish to. I take it you are declining.
I respectfully decline.
Well, please. All right, let me start this morning by acknowledging and thanking those that have come here today in support of their loved ones, and I appreciate your courage and your strength. And I hope that you are able to move on as best as possible. Thank counsel for the professionalism that they've exhibited throughout this case. It has been my great honor to preside in this case and to help bring, to the extent possible, some resolution and hopefully justice to this case. During the quiet morning hours of November 13, 2022, a faceless coward breached the tranquility of 6 beautiful young people and senselessly slaughtered them, 4 of them. Who committed this unspeakable evil was unknown for several weeks, but due to the killer's incompetence and outstanding police work by numerous local, state, and federal law enforcement agencies, the person that slithered through that sliding glass door at 1122 King Road now stands before the world and this court unmasked. This unfathomable and senseless act of evil has caused immeasurable pain and loss. No parent should ever have to bury their child. This is the greatest tragedy that can be inflicted upon a person. Parents who took their children to college in a truck filled with moving boxes had to bring them home in hearses lined with coffins. The loss this killer inflicted was not just the death of these people's children, siblings, grandchildren, as we've heard today. It has ripped a hole in their soul, destroying a special part of their very essence. Any person who is a parent defines themselves foremost as such. It is their existence and purpose of being. And it has been stolen from these parents. None of us have experienced the loss these victims have in the unspeakable way that they have. And therefore, none of us can, nor should we, question the way in which they have handled their loss. Whether that be in private mourning, removed as far as possible from this media circus, or in front of a camera demanding retribution with the loudest megaphone. I've listened intently to the stories and pain that have been shared today, with great awe at the courage and resilience of the surviving family members of those wonderful children. I've listened also to the surviving roommates, both in person and through their friends. And I can't think of how, frankly, courageous they have been despite the hell that they have faced by uncaring people who have come up with all kinds of crazy theories about 2 kids simply being kids. The parents, siblings, and other family members who have spoken today are designated as victims in our legal system. But going forward, I hope that they can shed that label, as it gives too much power to the evil that condemned them to that role. They are and should be known as survivors, fighters, and foremost as witnesses to the tremendous lives of value and unbounded promise of these 4 young people. But those speaking today and those who did not speak, but who carry this same burden, this same loss, now carry forward the memories of these now perpetually young people, these forever children. These survivors carry the responsibility of ensuring that the voices of these children, Maddie, Kaylee, Xana, and Ethan, are never forgotten, and the positive impacts that they have had on so many lives are never minimized, and that the love they shared, the light that they shined onto others, is forever celebrated. As we sit here today, this case is ending, and we are now certain who committed these unspeakable acts of evil, but we don't know, and what we may never know is why. I share the desire expressed by others to understand the why, but upon reflection, it seems to me, and this is just my own opinion, that by continuing to focus on why, we continue to give Mr. Kohberger relevance. We give him agency and we give him power. The need to know what is inherently not understandable makes us dependent upon the defendant to provide us with a reason, and that gives him the spotlight, the attention, and the power he appears to crave. Yet even if I could force him to speak, which legally I cannot, how could anyone ever be assured that what he speaks is the truth? Do we really believe, after all of this, he's capable of speaking the truth or of giving up something of himself to help the very people whose lives he destroyed? Rather, I suspect the so-called reason would be dished out in enticing, self-serving, and aggrandizing, untruthful bits, leaving people wanting more information, more insight, and thus enhancing even further the power he seeks to hold. Even if we could get truthful insight into his why, I suspect it would not in any way quench one's thirst for actually understanding why in the first instance. Because there is no reason for these crimes that could approach anything resembling rationality. No conceivable reason could make any sense. And in the end, the more we struggle to seek explanation for the unexplainable, the more we try to extract a reason, the more power and control we give to him. In my view, the time has now come to end Mr. Kohberger's 15 minutes of fame. It's time that he be consigned to the ignominy and isolation of perpetual incarceration. I know there has been concern about him collaborating on books or movies or other media projects, and I truly hope that someone does not stoop to affording him this spotlight that he desires in the name of clicks, royalties, or profits. While criminal behavioralists should study him away from the spotlight in an attempt to prevent other would-be killers from acting on their worst impulses, there should be no need for that to spill over into the public eye. The great Idaho jurist Edward Lodge was known for trying to find something positive about every person he ever sentenced. And with over a half a century as a trial judge, that was a lot of people. This was often challenging, and I recall in one case he said that the best he could come up with was the defendant had good penmanship. Truth be told, I'm unable to come up with anything redeeming about Mr. Kohberger because his grotesque acts of evil have buried and hidden anything that might have been good or intrinsically human about him. His actions have made him the worst of the worst. Even in pleading guilty, he is giving nothing hinting of remorse or redemption, nothing suggesting even a recognition or understanding, let alone regret for the pain that he has caused. And therefore, I will not attempt to speak about him further, other than to simply sentence him so that he is forever removed from civilized society. And accordingly, based upon his conduct and based upon the record before this court, recognizing the standards that govern this court's sentencing decisions as set forth in State v. Toohill, I hereby sentence Mr. Kohberger as follows. On count 1, burglary, 10 years fixed, 0 years indeterminate. I also impose a fine of $50,000. Count 2, first-degree murder of Madison Mogan. I sentence the defendant to a fixed term of life imprisonment without the possibility of parole, a fine of $50,000, and a civil penalty of $5,000 payable to the family of the victim. On count 3, for first-degree murder of Kaylee Gonsalves, I sentence the defendant to a fixed term of life imprisonment without the possibility of parole, a fine of $50,000, and a civil penalty of $5,000 payable to the victim of the family, or to the family of the victim, pardon me. On count 4, for the first-degree murder of Xana Kernodle, I sentence the defendant to a fixed term of life imprisonment without the possibility of parole, a fine of $50,000, and a civil penalty of $5,000 payable to the family of the victim. On count 5, for the first-degree murder of Ethan Chapin, I sentence the defendant to a fixed term of life imprisonment without the possibility of parole, a fine of $50,000, and a civil penalty of $5,000 payable to the family of the victim. The sentences on counts 1, 2, 3, 4, and 5 shall run consecutively to one another. Restitution will be left open for 60 days. Defendant will be required to submit a DNA sample and a right thumbprint impression to the Department of Corrections and comply with the DNA Database Act. I remand the defendant to the custody of the Idaho State Board of Corrections for to be imprisoned in an appropriate facility and execution of the sentence where he will remain until he dies. Though you have waived your right to appeal, you do have a right to file a notice of appeal, and any such appeal must be filed within 42 days of the date of the written judgment, which will be entered shortly hereafter. Though the appeal, you should be aware, may be deemed a violation of the plea agreement, and so I certainly suggest you discuss that with counsel if that is your desire. I ask the media and public present to allow the families to be escorted out first before they leave. Again, thank you to everyone for your stories today. I am strengthened by them, and I am encouraged by your humanity and strength, and God bless you. We're adjourned.
At his sentencing on July 23, 2025, the families faced him directly. They spoke of stolen futures, of empty beds, of unbearable pain. Goldberger did not speak. No apology, no explanation, no motive. Judge Stephen Hippler sentenced him to 4 life terms, plus 10 years for burglary. He will never leave prison. But the silence in the courtroom said everything. Justice may have been served, but closure never came. Why did he do it? Did he know the victims? Was it fantasy turned into action, a thrill kill, an attempt at the perfect crime? We may never know. Goldberger never gave a reason, and under the plea deal, he's not required to. For the families, the community, and a nation that watched in horror, that may be the hardest part to accept. Brian Goldberger now sits behind bars forever. But the legacy of his crimes lives on in the victims' families, in the scarred college town of Moscow, and in the disturbing truth that sometimes evil can walk among us, hiding in plain sight.
Step into the courtroom, the tension's high. Another name, another charge, another why. Truth don't lie, but people do. And we're here to break it down for you. From back alleys to the witness stand, we follow the facts, not just the plan. No sugarcoat, no holding back. If it's on the record, we're on the track. On the docket, lights on the case. Every motive, every move, every face. We don't just talk, we show and prove. Crime and justice in every groove. On the docket, truth in view. From the courtroom floor to the interview. The verdict's close, so stay right here. We break it all down, crystal clear. To the front page flame. No 2 stories ever end the same. We dive deep where the headlines fade. Find the facts that the silence made. No fiction here, just real